Welcome everybody to the next instalment of Contract Conversations and the first in England's Lockdown 2.0. This is a series of bi-weekly webinars being hosted by lawyers from across Mills and Reeve to discuss common issues which feature in contractual disputes, which people operating and drafting English law contracts need to be aware of. In today's session, we're going to focus on contractual obligations of good faith, and we'll also touch on the UK government's guidance in May and June of this year, requesting that parties act reasonably to each other in the context of COVID. My name is Mark Davison. I'm the Head of International Arbitration here based at Mills and Reeve in our London office, and I'm joined today by Sarah Jacobs.
Hi everybody, I'm Sarah Jacobs, as Mark said. I'm also in the London office, although not at the moment, and I'm a Senior Associate in the Commercial Disputes team.
Perfect. So there is a Q&A function, which hopefully you can find on the Zoom platform. So please do ask us questions, or if there are any topics that you'd like us to cover in this series, then please feel free to add those there. We'll try and deal with as many questions at the end. So onto the slide, just summarising what we're going to discuss today. So in respect to the first point about the UK government's guidance on reasonable contract behaviour, many of us will remember when that first was issued on the 7th of May 2020 and then was updated on the 30th of June 2020. And what that guidance effectively encouraged was for contractual parties to act responsibly and fairly in the national interest in performing and enforcing their contract. A question we were asked a lot at the time was, is it enforceable? And the simple answer is no. The guidance makes clear that it does not override any legal rights or obligations that the parties have under the contract that they've entered into, or otherwise in law, custom or practice, including any application of equitable relief. So really, what is the government asking? What does the government consider to be reasonable behaviour? So there was a fairly exhaustive list of examples that was given in the May guidance, in particular at paragraph 15. And I'm not proposing to read all of those out, but some of the examples that the government gave was that it asked parties to be reasonable when requesting or giving relief for impaired performance. So that includes in respect of time for delivery and completion of contract, the nature and the scope of goods, works and services, the making of payment and the operation of payment and performance mechanisms. It also asks for parties to be reasonable when requesting and allowing extensions of time, substitute or alternative performance and compensation, including compensation for increased cost or additional performance if the contract had been impacted by COVID. It also sort of requests parties to be reasonable as well when returning deposits or part payments, or making and responding to requests for information or data under a contract, or if a party requests a contract change or a variation. What was sort of most interesting about the guidance, though, was that it asked parties to be reasonable. And I say it was interesting from me as a litigation lawyer. They asked parties to be reasonable when parties were considering commencing or continuing formal dispute resolution procedures, including proceedings in court, and when requesting or responding to requests for mediation or other forms of ADR from parties. And so basically what the government has been trying to encourage parties to do through its guidance is to try and resolve contractual issues responsibly, either through negotiation, mediation, or other forms of ADR, before these escalate into formal disputes. And so quite interestingly, the government gave examples in the guidance of the Construction Industry Council and the Royal Institution of Chartered Surveyors that have both developed low-value fast-track ADR processes to try and resolve disputes early that have been impacted by COVID. So whilst I said at the start the guidance isn't enforceable, I would make 3 points on that. The first is that businesses should be aware that from a reputational point of view, the consequences if they do not follow the guidance. I mean, we've already seen in the context of COVID of where businesses have taken advantage of furlough where they didn't necessarily need to, that whilst that wasn't a breach of the law, the negative publicity that it's received as a consequence. The second point I'd make is that to the extent that a contract expressly requires a party to act reasonably, it could be expected that this guidance is one of the factors a court would consider when determining what is reasonable. And then the third point I'd make is parties need to remember that maybe some point or of issue in dispute between the parties which falls to the judge's discretion. So a good example of that is on the issue of costs, which is at the judge's discretion. And so what might happen is that you end up at the end of trial, you've won, you were found to be legally right, but you may be impacted on the cost that you recover on the basis that the judge may think that you litigated unreasonably in light of the guidance. There are no current reported cases on the guidance yet. It's not surprising, given that it only came out 5-6 months ago. And so it's very much wait to see this space in terms of when disputes that cite the guidance start to go through the courts.
Thanks, Mark. So I'm just going to build on what Mark was saying with his second point, which is, well, what do you do with this guidance when you've got a contract that expressly tells you that you have to act in good faith? So there's two types of clauses that I'm going to call express clauses here in a contract where this might come into play. The first is a little bit complicated, but it's basically where a contract has a clause in it that gives one party the right to make a decision that affects both parties. So that party, for example, say Mark and I are in a contract and I have the power under the contract to make a decision that affects not only me, but it affects Mark as well. And because I'm a commercial person and, you know, I've got a business and I want to make the best decisions for my business, there's an inherent conflict of interest there because I'm obviously going to always put my interest first over Mark's. So an example is, you know, if there's a right to unilaterally vary contract fees in a contract. So that's the first type of clause, which I'll come back to. And then the other type of clause is a bit more simple, which is when you have an express duty in a contract that says the parties should act in good faith. So just returning to that slightly more complicated first type of clause, the reason why this might come into play is because sometimes with these types of clauses where one party has the power to make a decision, a court will read in a duty that that party, so in the example I gave before, me, has to make that decision in good faith and rationally. So basically to stop me abusing my role as the decision maker because of that inherent conflict of interest. And that's called the Braganza duty, which is on the slide there, which is based on a court case with the same name. So basically the idea is that I don't have to make my decision in Mark's interest, but when making that decision and exercising that discretion that I have, I need to take into account all the relevant considerations and not be sort of unduly harsh. And that's what sometimes the court implies into those types of clauses. So in the context of COVID-19, you're unlikely to see this in relation to the types of clauses that we've seen it come up time and time again in the last 6 months. So force majeure clauses, frustration and termination clauses. They're unlikely to attract this type of duty. So you don't really need to worry about it with those types of clauses. But for example, if I'm in a contract with Mark and I'm supplying services to him, all my other contracts have fallen away, I'm struggling financially and I've got a power under the contract to unilaterally hike up my prices with no input from Mark, and I might do that. That's where you've got to tread quite carefully, because that's where, if this ended up in a dispute, a court might say, well, hold on, Sarah, you need to make that decision rationally and in good faith. So in terms of how the government guidance that Mark took us through before plays into this. We're not really sure how this will actually play out. As Mark said, there's been no reported cases yet. On one hand, it's unlikely that the courts would actually use the government guidance to take this any further than they've already got it to. They've always said it's a matter of construction of the contract. So, you know, they're not concerned about things outside the contracts. They look at the relationship between the parties and what the actual words of the contract say. So it seems a bit unlikely that this government guidance issued later in time would affect what the court does in terms of their interpretation of the contract. But on the other hand, it is 2020, who knows what's going to happen, and a court may be more inclined to impose this type of duty, so just to act rationally and in good faith, given this government guidance, than it previously would have been. So I guess the takeaway from that is keep an eye out for those types of clauses and make sure that if you are the party that has the power to sort of unilaterally hike up prices or something like that, that you keep a record of your decision making and that you sort of take into account all reasonable considerations, which I'm sure you would anyway. Now, moving on to the slightly more simple type of clause where the good faith alarm bells start ringing, is when the parties have actually expressly said in their contract that they promise to act in good faith towards each other, which is something we do see sometimes, or they use wording to that effect. So they might say that Mark and I in a contract might say we agreed to resolve any disputes between us by friendly discussions, whatever that means. And courts do try and give effect to such clauses because they have, you know, the parties have sort of expressly tried to put them in their contract and agreed to them. But it's difficult because the terms are quite vague. You know, what does my friendly negotiations, my friendly discussions might be different to what Mark's friendly discussions are, and how is a court to judge whether a party has complied with that or not? So for that reason, they do put limits on these types of clauses, the courts do. So I'll just run you through a couple of those. If there is a sort of wide good faith clause that the parties must treat each other nicely and in good faith, if there's a specific right set out in the contract, that's going to prevail. So, you know, if I have a specific right to withdraw my services with no notice and still charge payment, that's going to prevail over a more general good faith clause. These types of clauses as well do not affect sort of hard contractual rights, they're called, so like your right to terminate a contract. So you can still do that. The good faith clause doesn't really come into play with that. And the other thing that the courts say is that a duty of good faith, it's not a duty for me to put Mark's interests above my own. It's just a duty to recognise the legitimate interests of both of us. So, you know, you can still be commercial here, even if there is a good faith clause. So again, how does this all work in the COVID context and with this government guidance? Now, the English court might take into account government guidance when deciding whether the party has acted in good faith or not. As I said before, it's very vague, it's very subjective, so they might look to the government guidance to sort of help them to say, okay, what would have been a reasonable thing to do in these circumstances? And they might look for these types of clauses with a bit more enthusiasm, and potentially could interpret the clauses more expansively than they have in the past. But in saying that, we think it's quite unlikely to lessen those limits that I've just set out on the scope of these types of clauses, because the courts have spent years and years and years developing this case law about how to interpret these types of clauses, and some government guidance is quite unlikely to change that.
Perfect, thank you, Sarah. Just on the next point on the slide about implied duties of good faith. So basically, if you haven't got an express duty of good faith under a contract, would a court ever imply a duty of good faith that the parties are required under the contract to act in good faith to each other? And if you'd have asked me this question about 10 years ago, I'd have said the answer was no. The English courts would not imply a duty of good faith. But there has been a creep in recent years, and the creep all started about 7 years ago in a case called Yam Seng, which I appreciate a lot of people on the call may have heard of. And so in that case, basically, the judge implied that there was a duty of good faith in a distribution agreement, which I think was to sell Man United branded fragrances in airports in various countries around the world. The claimant in that case had alleged that the defendant had failed to act in good faith because the defendant continued to sell products into the retained markets that the distributor was supposed to sell into, but at prices which undercut those which the distributor was required to sell at under the terms of the contract. And also the defendant had had provided false information to the distributor as well. And so the judge held in that case that there was a requirement of good faith, and that could be implied in any ordinary commercial contract where it's consistent with the presumed intention of the parties. And at the time, this was a fairly radical approach, and there was lots of discussions about it in the market. And effectively, what's happened since Yam Seng is that later judgments have given a relatively narrow interpretation to Yam Seng, and there has been a rowback in terms of the consequences of where we were left after Yam Seng. And the recent cases have all showed that good faith will only be implied into what we term relational contracts. And so in order for there to be a relational contract, it's generally where the contract that you have is one which is over a long period of time with the mutual intention of a long-term relationship. The parties intend their roles to be performed with integrity and fidelity to their bargain. The parties are committed to collaborating with one another in the performance of the contract. The spirits and the intentions of the venture might not be capable of being actually expressed completely in the written contract. And the contract effectively involves a high degree of communication, cooperation, and predictable performance based on the mutual trust and confidence of expectations of loyalty. So that sounds sort of quite complicated, just in terms of some examples of where the courts have found relational contracts. So there was one called Bristol Ground School, which involved a 10-year contract where a party had wrongly taken and started using the other's IP without paying for it. And it was found that given the period of the contract and the fact that the person providing the IP assumed he would be getting paid for the IP over the life of the contract, rendered it a relational one. There's another case called D&G Cars and Essex Police. This involved a contract which had an initial term of 5 years, but it was anticipated that the contract would be extended past there. And basically the party in that case was crushing cars that it recovered for the police. Sorry, it was supposed to crush cars that it recovered for the police, but effectively what it was doing was incorporating them into its own fleet of cars, which was contrary to the contract. And the court found there that there was a relational contract. But even if you can establish that the contract that you have is a relational one, courts will only imply a duty of good faith or terms amounting to it where it meets the usual requirements to imply terms under English law anyway. And so, put simply, that's effectively where the term is necessary to give business efficacy to the contract, or in order to give effect to what was so obvious that it almost goes without saying. So in January this year, just as an example of how that works, there was a case called Tacker and Rockrose, and that found that, yes, there was a relational contract, but no duty of good faith could be implied or should be implied, as the clause that was actually being relied upon provided an absolute and unqualified power to one of the parties. And so it was clear that the parties had agreed. So it would effectively, that clause was so clear what the parties had agreed that there was no need to actually imply a term to give the contract business efficacy. So ultimately, implying terms remains fairly rare under English law, and implying duties of good faith is rarer still. I think in respect to the government's guidance, I don't think that will change the analysis of whether or not a term should be implied into the existing contract. So I don't think there's really much to be seen following the guidance that was issued in May and June of this year. Just in respect of the penultimate point about civil law jurisdictions, I only raised this, so I spent quite a lot of time working in the Middle East, and I've been involved in lots of disputes which have touched on civil law. We've worked with civil lawyers, and with experts giving evidence on civil law in disputes that I've been involved with. And I think as many people on this call will know that where civil law jurisdictions are involved, good faith is often a fundamental concept in most, if not all, of those civil law systems. You can trace it back to Roman law. I'm not going to propose going on a history lesson of the development of good faith from Roman times. But effectively where we are now is that different systems approach it in different ways. But just to give you an example, under Article 171 of the Qatari Civil Code, it states that a contract shall be performed in accordance with its provisions and in such a manner consistent with the requirements of good faith. So you can see how that could operate when you have contractual relationships with other parties which may be under a civil law system. I think traditionally where English lawyers get involved in disputes under civil law and they see a good faith argument, we tend to see it as just being the final alternative argument, very much the kitchen sink argument that are raised by the party that's been raising it, sort of a case of buyer's remorse. But effectively, I think the takeaway from this session is that if you're dealing with a contract which is governed under a civil law system, just to have in the back of your mind that there are provisions of good faith in most, if not all, civil law systems.
Okay, thanks, Mark. So I'm just going to conclude on what should you be doing now with all of this good faith malarkey. So I get the key point to remember, as Mark has already said, is that this government guidance is not enforceable. So no one can sue you and you can't sue someone else based on that guidance alone. But there are spaces where it could come into play. So when there are express duties of good faith or implied good faith duties, which is what Mark's just been talking about, when there's a relational contract, we think it's probably unlikely that this government guidance is going to play a huge part, but it is something to bear in mind. Where it is more likely to come into play is, as Mark touched upon at the start, is where the court has a chance to use its discretion. So, for example, if they're assessing costs at the end of a trial, they might point to the fact that a party hasn't acted in accordance with the government guidance and say, well, that's a reason why they should have costs awarded against them, just as an example. So what can you do? I think what you can do is just keep an eye out for good faith type clauses in your contract, or those types of clauses that give one party that unilateral decision-making power. Or if you're in a contract where you think this is a long-standing contract, it might be a relational contract where a court might imply a duty of good faith, you should just bear that in mind in your actions. Ultimately, it's probably the safest thing is to try and play it as nice as possible within the confines of your commercial objectives.
Perfect, thanks, Sarah. So that's the end of today's session. We'll just try and deal with some of the questions that have been raised. There's one here about whether an English judge would enforce, effectively, would they enforce a civil law concept of good faith? And the answer is yes. If the dispute needs to be determined under a foreign legal system, then English judges are well versed in dealing with disputes under foreign law. The way it's usually dealt with is that foreign law is dealt with as a matter of fact. So it comes down to expert evidence from foreign lawyers who, unless it's agreed by the parties, but usually it's an expert from the foreign jurisdiction in question that gives evidence as to how that legal provision operates in that jurisdiction, for example. So if it's a point an issue is on good faith, then you'll have experts giving evidence about how good faith operates in that jurisdiction. And then a judge, an English court judge, will make a determination on that issue. There is just one question here about sort of COVID and labour and material shortages. I think that's coming down to construction issues, and so what I might do is I might just follow up with that individual separately after that. But it's depending on which construction law precedent that you're using. If you're using one of the standard form contracts, so whether it's FIDIC or NEC or JCT, it could operate in different ways. So I think there is something within NEC which is sort of akin to a good faith requirement, just given the way that that was drafted. But I might just follow up with that individual after this session. I think that's it in terms of questions. And I think due to time, we're almost at 12:30, so I think we'll finish up there. If you've got any questions and you didn't want to put it in the Q&A box, then please feel free to follow up with us after this session. I'll just put up Sarah's and my QR codes, which are there. If there are any particular topics that you'd like us to cover in this series, then please do get in touch. As you leave this session, there should be 2 pop-up questions, which just ask for you to provide some feedback on this session, which I'd be grateful if you could just answer. The next contract conversation in this series is in 2 weeks' time, on Tuesday, the 24th of November, where Eric France and I will revisit frustration and force majeure and where we are 6 months on from the start of the pandemic. I hope you're able to join us for that. Thank you very much for your time today, and thank you very much to Sarah.
Thanks very much, everybody.
And I hope you have a pleasant afternoon. Thank you very much.
Thanks, bye.